It is July 8th of 2026, and this is the Court Gallery. Coming up, we begin in Judge Stevens' courtroom, where one man's foolish statement during a traffic stop turns a simple ticket into a potential 10-year prison sentence. Then, we hear from Judge Simmons, who's presented with a wild story about a defendant being kidnapped by the complaining party against her, which is why she missed court for her criminal matters. Judge Simmons has questions. And finally, Judge Hunter presides over attempt sentencing for a defendant with 25 prior convictions. Some people just never get the memo. From baffling excuses to jaw-dropping criminal histories, all that and more starts right now.
Cameron Mitchell.
Nichols?
He told me he felt as horrible as second.
26 CR 928 is now called the State of Texas versus Cameron Nichols. Is that you? With Mr. West here, your attorney and the state's attorney is going to be here, and that's going to be sure who it is. And it this alleges that you committed the third-degree felony of obstruction or retaliation, that you intentionally or knowingly threatened to harm another person with assault in retaliation for or on account of them acting as a public servant, namely a Loma police officer. This, okay. Apparently, the patrolling officer observed a silver Honda. I guess you were in that with an expired registration. And they stopped you, and then you were placed under arrest for multiple city warrants. As they were investigating, according to this, you told the officer, "I'll slap the shit out of y'all when y'all take the cuffs off." Nice. How'd that work out? They just didn't let you go, did they? Might as well say, "Please arrest me now." Take me. I mean, that's about as foolish of a statement as I've heard. And I've only been doing this for 45 years. Speaking you were speaking to multiple officers. Well, they decided that that was a crime of intentionally or knowingly threatening to harm another who were operating in public servant positions, the officer, and you were taken to jail and booked. The only thing to explain that is you must have been intoxicated, out of your mind or something, because who would say that? What do you think is going to happen when you see? You think they're going to shake your hand and give you an award for politeness? You're going to get arrested by threatening an officer who's conducting an investigation. And that's why you're looking at up to 10 years in prison if convicted. Okay. John, yes.
Initial appearance, Your Honor, if we can get about 4 weeks or I don't know when my next, I know that's a vacation.
4 weeks, you got it.
4 or 5 weeks, whatever my next, Ellie knows my knowledge. She knows my schedule. So whenever I'm back.
Uh-oh.
The kids. Yes.
It's the kids. Hmm?
We weren't saving children.
Mm-hmm. Yeah, JD's good. What does he have a criminal history? I don't know.
He's got an arrest for something else. I don't know what happened to it, but
No.
I don't think he's had them.
What's the UMHB? What is that,
They are notes.
sir?
College.
University of Mary Hardin Baylor.
Oh, okay.
University of
Yeah.
Michigan.
Okay. I get a reset in 4 weeks, and sir, be polite, whether you like to be stopped or not. It's not funny. I mean, you're looking at 10 years. What are you laughing about? It's 10 years in prison is serious. It does, you know, and everybody makes a mistake, and all of us get stopped for some reason by the police over our lifespan for something, speeding or something. But that isn't the way to handle it. By getting all that was a ticket at the worst, and then they let you go, and now here you are looking at 10 years in prison. You got to understand, this wasn't a wise idea. If all of this is true, here you are. You're having it's going to cost too. It's going to cost you money plus time.
Over there, I'll meet you right outside, okay?
Renya Boudreaux. That's you now?
Yes.
Actually, we have two cases here, right?
Mr. Simpson, my understanding is there may be some misdemeanors coming forth. So
All right, just so you know, before the court are two indictments here with your name on it. 26 CR 747 and 748. In each of these cases, you are charged with the state jail felonies of credit or debit card abuse. Each of these cases carry with it up to 2 years in the state jail. So you're looking at up to 4 years in a prison type facility if convicted. And well, you do this thing long enough, you see it all. So you're charged with these two state jail felonies of credit or debit card abuse. Question I had, of course, was how in the world do you get access to somebody's credit card and then use them? Well, you're working at McDonald's. And they give you their credit card to pay, and then you take photographs of their cards and then misuse them later. That's low. That's low. Shame on you for that. It hurts McDonald's because now people will have questions about the security of their monies. But when they give that to you to pay, they're assuming that you're going to be trustworthy enough not to misuse it, but not you. You didn't do it on one case. You did it at least twice with two different people.
It's better.
I'm sure, I hope McDonald's has changed the way they do things, but when you can't trust people like that, like this, it puts a hamper on just the way we make purchases. But people give their credit cards to others all the time to make payments. And we trust that someone like you is not going to take a photograph of it and then misuse it. I guess McDonald's got rid of you. They fired you when they found out. It's the least of your problems. And now you're looking at up to 4 years in a prison-like facility. This is terrible. This kind of thing, because everybody uses credit cards on it, literally, and we have to trust that it's not going to be misused by people like you.
Yes.
Shame.
as,
All right,
as
that's
it
my
turns,
speech.
as it turns out, Judge, she was on misdemeanor probation at
At
the
the
time.
time, for what?
That was for evading arrest or detention. There's an administrative hearing that's approved a motion to revoke her probation that has not been filed yet. We were trying to resolve all three of those cases when I looked in our system and saw that we received two more misdemeanors on her that were alleged to have been committed on June 27th. So,
So this year?
yes, sir. So I haven't had a chance to look at those, and that of course is gonna,
You mean she is allegedly committing crimes after she was indicted?
that's what it appears to be. And I know how sensitive the court is to that, as I am too, but I have not had an opportunity to look at that. Like I said, they were received yesterday. So, and it may be that we refuse those. There's no telling. I don't know what the details are on there, but I am concerned.
But she's out and about.
Correct.
No, I can revoke her bond and stick her in jail until this all gets finalized, which is probably in the best interest of at least 250,000 people in Jefferson County who trust that their credit card won't be misused. But anyway, that's but she's out and about.
I have concerns about flight because now we've told her in the courtroom about a warrant that's coming and two additional cases.
Well, that'd be another crime.
Yes, sir.
And y'all always catch them.
Yes, sir.
But anyway, yeah, I don't have anything before me other than this until y'all do a formal charge or get me a complaint. And then we have a hearing on this. Then I'm not changing the bond, but I will change the bond if you're committing crimes while on this court's bond. Taking that I'm administrating in your cases, if you've got pending cases and you commit crimes, then your bonds will skyrocket up. I'm not going to let you continue to harm people after you realize that we're holding you accountable and this is serious. And if you can't figure out that means stop committing crimes, then you're a danger to the community.
I'll look into those matters today,
Yeah,
Judge.
I don't trust her at all. I mean,
Yes,
this is
sir.
serious. The poor people, and here's the deal: their credit is ruined. Their credit, they've got to fix their credit now. You've got problems with their credit card company, with their credit worthiness that most people work hard to prevent from being bad, so that they can continue to have access to credit if they need it. People like you foul that all that good work that they're trying to do to keep their credit worthiness from being blemished. You come up and foul it all up, and then they're the ones having to pay for it. Shame on you. Thou shalt not steal. You heard that one before? It's a kind of an important rule. One of the top 10, as I understand. Shame on you. All right, let me know, because I don't want her out
Yes, sir. I know.
being a harm to everybody else. And you're asking for 4 weeks?
Yes, sir.
All right.
Judge, can we keep a shorter leash so that I can check into this? Maybe a week or two instead of 4.
Well, let's review it in 2 weeks.
Thank you,
Okay,
Judge.
What day is it now?
sir?
22nd.
I
Okay,
guess
you're
so.
good, you're good. The next week.
Don't commit more crimes. I don't know why I have to say that.
Joshua Humig and Andrea Humig, petitioners, versus Christopher Jacob Finch, respondent, case number 2024 DM 251. Counsel, would you announce appearances, please, beginning with petitioners?
Thank you, Your Honor. Susie Locke appearing on behalf of Josh and Andrea Humig, who appear in my office and via Zoom.
Ms. Williams, you're muted, so
My apologies, Judge. Joy K. Williams on behalf of Christopher Finch, who appears via Zoom from his residence in Texas, and I appear via Zoom from my office in Wichita.
all right, who is seated beside Mr. Finch?
That would be his wife,
And her name?
Ashley.
All right, thank you. This matter comes before the court at this time for a scheduled hearing on a contempt citation that was previously filed and served through special process server on Mr. Finch in Texas. However, Mr. Finch, non-responsive to the requirement that he be in court in person for today's hearing, is not in Kansas. Ms. Williams, do you have an explanation?
Yes, Your Honor. My client was not able to drive up today. He had suffered a car wreck on July 4th. I sent the court some pictures of the wreck. He was rear-ended at 70 miles an hour. You saw the damage to the vehicle. Since then, he has increasingly been in pain. I sent one page of his medical report that he had to seek medical treatment on the 6th. He is still informs me he's in a lot of pain and was not able to make the 9-hour drive. In fact, after the wreck, he drove a little ways, but then had someone else come and pick him up because of the pain he was in. So that is why he is not here today, Judge, and he was requesting a continuance.
Ms. Locke, what is your response to this request?
Your Honor, we're objecting to the continuance. Mr. Finch has another child named Ricke, who he had for visitation in June, for the month of June. His accident occurred on his way to Kansas to bring that child to Kansas. He did bring the child to Kansas on July 4th. He went home to Texas.
Wait a minute. I thought he had a wreck on the 4th on the way up here.
He did.
He did, Judge. And
But
then
he went ahead and completed the trip to Kansas?
correct. And then on July 5th, he returned to Texas. Now, July 5th was the day that he was supposed to bring Dawson, the child subject in this matter, to meet my clients at Shields in Wichita. He brought one son with him to Kansas and didn't bring the other child, who was supposed to be exchanged on the 5th. He was in Kansas on the 5th. Then he drove back to Texas and now is claiming that he couldn't appear, and my client's visitation with their grandson still hasn't started.
Your Honor, if I may clarify some of that. That was on the 4th. His exchange with the child in this situation was not supposed to happen to the 5th. And the other half of the family was supposed to come up with Dawson. What happened was he had the wreck. He went ahead and finished driving from Texas, but then he could not return because of the pain he was in. So he had to wait and have someone come pick him up
What's
and
that
drive
got to
him
do
back
with
to
anything?
Texas.
Ms.
Yeah.
Williams, what's that got to do with anything? If he came to Kansas and he was supposed to have this child in the car with him, he drove all the way to Kansas without the child involved in this case?
The exchange was supposed to happen the next day, and as I said, the other half of the
Okay, now,
family
wait a
was
minute.
coming
Okay.
up with him, with that child.
I'm not understanding here. If he was coming up on the 4th from Texas to Kansas, then the child involved in this case should have been with him, shouldn't he?
That was not the plan. The plan was for his wife to bring Dawson, the child in this case, up on the 5th. Because he had to get the
Why
other
wouldn't
child
he
up
just
by the
bring this
4th.
child up on the 4th?
I don't know why they made that decision, but it was going to be that they were driving separately, which was actually fortunate that the child wasn't in the car, but then he wasn't able to complete the journey because of the wreck.
Well, he did complete the journey because he drove the rest of the way to Kansas.
But then he couldn't travel anymore driving himself
Yeah,
because
but who
of
cares about that? At that point, the child should have been delivered to the Humigs on the 5th, and then whether he gets back or not wouldn't really been relevant to today's court case. How come, if that was the plan, how come Ashley didn't follow through on her part to get this child up to the Humigs on the 5th at 7:00 a.m.?
I would assume because of the chaos of the wreck, you saw the aftermath of the wreck, and he sought medical treatment after that. So it ended up
On the
not
6th.
happening.
So for 2 days, he didn't seek any medical treatment, but on the 6th, well after he should have been delivering this child, then he sought medical treatment.
The medical record is from the 6th. That is correct, Judge.
Well, okay, so is there going to be any explanation offered why this child wasn't delivered on July 5th at 7 like he was supposed to be? Because a car from Texas made it up here. And why in the world he would have a second car bring this child just boggles the court's mind. I do not understand that at all. What it sounds like, Ms. Williams, is that the court's orders are being intentionally obstructed at this point. There's some sort of games being played here, which this court is not in favor of. This child should have been turned over to the Humigs on the 5th at 7 o'clock like he was scheduled to be. And why the dad would be coming up to Kansas on the 4th and not bringing this child with him, I just cannot fathom.
Your Honor,
I sure hope this wasn't done with any advice of counsel, Ms. Williams.
no, Your Honor, no. I would hope the court would know me from all the years I've practiced in front of this court. And
He claims he couldn't make the trip to Kansas.
Your Honor, that is the request. I know that my client has told me that he is in pain and could not make the drive.
How convenient. All right, Ms. Locke, any further presentation by you?
Your Honor, obviously our position today is that this court still has continuing and exclusive jurisdiction over this matter unless and until it is taken up in another court. Our request today is that visitation start immediately. My clients, this is day 8 of missed visitation over the summer. Dawson was not exchanged for their June visit despite them driving to San Antonio. And now he was supposed to be exchanged on the 5th and they do not have him. Ms. Williams disclosed to me earlier today that there has allegedly been an adoption in Texas. My clients were not given any notice of that. We have no case number. We have no information about any supposed adoption of Dawson. Texas does have the UCCJEA, so this case should have been disclosed to any case involving the minor child in Texas, which my client should have received notice of and did not. So we're asking the court demand that the father provide the adoption file if that did occur, or at least the case number. And then reset the contempt hearing so that the issues in our motion can be properly addressed by the court.
What is your authority for the proposition that the grandparents were entitled to notice of the adoption proceeding in Texas?
Judge, I do not practice in Texas, but my understanding is that if there is a pending case, a pending court order giving someone else visitation rights in another state, that they have the ability to intercede in an adoption in Texas, and are to be provided notice of the adoption and the opportunity to be heard, especially if it involves a step-parent adoption where there is a deceased child and the grandparents have visitation rights.
I will expect you to provide the court with specific legal authority for your proposition. Ms. Locke,
Understood,
I'll
Judge.
take your request under advisement until that authority is presented to the court. And I think
all
that we're
candor,
probably
Judge.
looking at Texas law that would apply to a Texas adoption proceeding.
In all
Yes.
candor, Judge, I do not have a copy of the adoption. Like I said, I've not been in contact with Texas attorneys on these matters.
Wait,
Well,
So I don't
we
have
don't
a
even
copy.
know that an
Advisement.
adoption exists, Your Honor.
And I'm not sure what notice provisions would be afforded the Humigs under Texas law, since they're not parents whose rights would be terminated through an adoption, but I don't know Texas law either, so.
Well, the court's first temptation is to issue a bench warrant for the arrest of Christopher Finch due to his failure to appear at the Kansas contempt proceeding. I am far from convinced that he was physically unable to appear. I think he just didn't want to. And I do believe that he's intentionally obstructing the court at this point and has no intention of complying with Kansas court orders. He should have been here. And there is certainly insufficient medical documentation before this court for this court to grant a bona fide medical excuse for his non-appearance. However, this court did convert this hearing to Zoom. Mr. Finch has appeared on this hearing. What the court believes the proper remedy at this point is to grant a short-term continuance and to reset this in very quick fashion for an in-person contempt proceeding in the District Court of Butler County, Kansas. Council, I'm looking at Tuesday, July 14, next week, 11:30 a.m. Ms. Locke?
I'm available, Your Honor.
July 14th at what time, Judge?
11:30.
Your Honor, I have a couple Zoom hearings that morning, followed by having to be in court at 1:30, so I don't know that I would be available.
I'm not going to let your unavailability impede the court's ability to proceed on this case, Ms. Williams. Move whatever else you have or get a substitute attorney to represent Mr. Finch. Now, Ms. Locke, I would accommodate, but you're requesting this continuance. I want this matter heard without delay, and I want him here in Kansas to face the music for the allegations that Ms. Locke is making regarding noncompliance with court orders. So, Tuesday, July 14 at 11:30. Mr. Finch, you are ordered by this court to be personally present, courtroom B, Butler County Judicial Center, El Dorado, Kansas, at that time. And your failure to appear will result in a bench warrant for your arrest. July 14, 11:30 a.m. Now, with all of that said, Ms. Williams, what appears to be, at least prima facie, of contemptuous behavior on behalf of your client could be remedied to some extent if the exchange of this child can take place here in short order.
Okay. Yes.
Oh.
I will talk to Mr. Finch and see if we can accommodate that and arrange something with Miss Locke. I'm sorry.
Talking about a little boy having time with his grandparents. I just failed to see that there should be insurmountable hurdles into making that happen. The court would certainly take into account Tuesday, July 14th at 11:30 when this matter is next addressed. All right. Again, Ms. Locke, your request regarding the adoption file, I'm going to wait on authority. I'm going to presume if you don't provide that authority that you don't have any, and the court's not going to take any further action on your request.
Understood, Your
I
Honor.
do think that the matter is governed by Texas law rather than Kansas.
Yes, Judge.
So unless you can find some other applicable authority that would override that determination. All right. Ms. Locke, anything else at this time?
No, Your Honor.
Ms. Williams, anything further?
No, Your Honor.
All right.
Judge, I want to confirm that I do not have to re-serve Mr. Finch.
You do not.
Okay.
This is a continuance of the hearing that was supposed to be held right now. So, no, you do not. Mr. Finch, you were advised accordingly. All right. There's nothing further at this time. The Humig versus Finch matter will currently be in recess. This meeting may be ended for all at this time.
On the record in the matter of the state of Michigan versus Whitney Rice 25-03766. Appearance, please. I'm waiting to have the public defender log back in. I'm assuming she did not speak with Ms. Rice. Is that accurate?
She did. I was advised that she did, Your Honor.
Oh, okay. Well, I don't know what happened. Okay. We're on the record in the matter of the state of Michigan versus Whitney Rice 25-03766. Can I have your appearance for that record?
Linda Rawls, Assistant Public Defender with the Ingham County Public Defender's Office, appearing on behalf of Whitney Rice, who's appearing via Zoom for her arraignment.
Okay, Ms. Rice is here. There is a domestic violence that she is in bench warrant status on here. Let's see. It looks like she had a pretrial back on March the 3rd, 2026 at 2:30, to which she failed to appear before Judge Buchanan. And then let's see. That was after having a previous failure to appear back on December 29th. And so it also looks like there was a bond violation that was scheduled or should have been scheduled for a hearing also on the 3rd of March that Miss Rice would have failed to appear. Miss Rice, did you forget that you had court?
No, I did not, Your Honor. I was not allowed to make that. I was in an abusive situation where I was held down at the floor, not allowed to use the phone, and beat up.
Oh, okay, so you were in, you said a hostage type situation?
Yes, kidnapped, actually. Completely true.
Okay. You were kidnapped by whom, ma'am?
Richard Parmenter, or at least one of them.
You said one of them?
Yes, there's multiple people that go by the same name.
Okay, there's two Richard Parmenters, is what you're saying?
That I know of, at least, yeah.
Oh, okay. And back on February 18th, I think I arraigned you. And I gave you a bond of 5,000, 10% with GPS tether. Are you still on tether? Were you still on tether when you were kidnapped?
I don't remember, Your Honor, no.
Oh. Okay, well, your matter's going to be reset for a pretrial before Judge Buchanan. It's going to be on July 21st at 9:30 in the morning, okay?
Okay.
Counsel, did you want to address bond?
Yes, Your Honor. We do realize that there was a failure to appear. And so I understand that there may be some concern regarding the defendant's ability to attend the next hearing, but we respectfully ask that the court allow for a 10% bond so that she will be able to have an incentive to appear at the next appearance.
I'm not sure, Ms. Rouse, what level of interaction you had with Ms. Rice. I am familiar with Ms. Rice. I believe I last year had to remand her I believe she was on probation. And it was the same victim in that case too. But just judging by some of the statements that was made here today, the court actually has a concern about her mental wellness. Not just the statements that was made, but also there was a letter that it appears that she forwarded or mailed to the court as well. So there are some concerns there that I think her attorney would want to flesh out to make sure that an evaluation is not warranted. She has a history of failing to appear. She did have a 10% bond in February with GPS tether, and she can't even tell me if she remembers if she has a tether on at the time that she was allegedly abducted by the victim in the domestic violence case. With that being stated, I don't believe that she is a good candidate for another 10% bond because she's had that with tether, and it was not beneficial. In addition to that, we already have a pending bond violation from February as well. Again, indicating that she violated the no contact order and was in contact with the protected party. And the protected party allegedly called 911, indicating that his girlfriend, Ms. Rice, needed help, which would have been in violation of her bond because she was not supposed to be wherever he lives, works, or goes to school. So with that being stated, a bond at this time is set at 5,000 cash only with GPS tether. She needs to make sure she appears to all of her court dates. I will note that there is the possibility that she may need a psychological evaluation. But I'll leave that for her counsel to speak with her further and determine whether or not additional evaluation is needed. She was at the time, I believe, represented by Ms. Wicks, but I don't know if at this point, we've probably received a motion to withdraw from your office.
I think it's George.
Okay, I do see an appearance from George and Ned from February. I do not see a motion since February to withdraw. So she is represented by your office by Mr. and Ned. And so the violation hearing and the pretrial will go forward on this 21st at 9:30. If you do postpone, Ms. Rice, you are required to appear in court for your next court date, okay?
Good.
You also are not to have contact with Richard Parmeter. Do you understand that?
Yeah.
That would include calls from the jail, which are recorded. You understand that?
I do.
Okay. You're not to engage in any assaultive or threatening behavior. You're not to use, purchase, or possess drugs or alcohol without a valid prescription. You're not to possess a firearm, ammunition, or weapon of any kind. And you're not to travel outside the state unless you get prior approval from the court. Do you have any questions about your bond?
No.
Any additional matters for the record today, counsel?
No, Your Honor.
Okay, you're all set, ma'am. Thank you.
Thank you, Your Honor.
Thank you. Thank you, Ms. Ross.
Thank you, Your Honor.
Thank you. Let's see.
Court does call the case, People State of Michigan versus Nicole Henderson.
Morning, Judge Simpson and staff. Nicole Sadi. I represent Ms. Henderson, who is coming up to the podium now.
Your name?
Nicole Henderson.
Go ahead, counsel.
Your Honor, so this morning I did file an emergency motion in person regarding the bond. I'm not sure if you're able to hear that in the moment or schedule an immediate hearing on it. I was informed that I tried to communicate with the court. Ms. Henderson had secured Mr. Statman's services to do a substance abuse assessment. We understood from what you said from the bench last time that you want to read the assessment prior to making any form of a bond reduction. The jail was asking in order for remote participation for an order from this court. I did attempt to send proposed orders to the court, but there is an issue apparently with my emails not just being received through this court. So I will correct that immediately. I don't believe that I printed a copy today. I believe you have one electronically. If you're willing to hear.
I back up a moment, counsel. You sent an order to the court today?
No, yesterday. And I had also sent a request for a remote hearing on Monday, but I showed Ms. Wielding my emails. My emails were sent. They were not received. I did have a hack event last week through one of my email accounts. It was a party invitation that was not a real party invitation. I never should have clicked on. I thought I had secured the emails, but I believe Ms. Wielding didn't receive them. I didn't get a bounce back, so I'll have to correct that issue. But I wanted to make you aware that I've attempted some communications.
And then you've indicated that you filed an emergency motion?
I did a bond motion, Honor.
Is that this one?
Yes, it is.
I believe what's in your hand.
This one?
Yes.
Well, I don't mind. I take it, Mr. Cook, that's why you are here today.
Yes, Your Honor, we're here for a pretrial as well as a bond review hearing. I was served a copy of that motion this morning. I was able to read through it. Most all the information in the motion, I believe, was already placed on the record, so I was already aware of all of this. So I'm ready for the on the motion if the court wants a response. I'm fine with doing that hearing today if the court's inclined to do so.
All right. Well, go ahead, counsel.
My thought would be, as the court indicated previously, we want to see substance testing. Obviously, Ms. Henderson has this OWI case, the out-of-county OWI case, as well as the pending malicious destruction matter. My concern is making sure that she gets substance abuse counseling. And from what I'm hearing, it sounds like that being done in custody is creating additional hurdles. I don't know. I spoke briefly even with Laura. She indicated she may have a different individual who could do a substance abuse testing in custody. I'm not sure if that would be faster than for Mr. Statman to do a remote hearing with this defendant. I don't know the time frame on that, but I want to make sure that whatever way we move forward, go expeditiously to get her started with that counseling as soon as we can. Obviously, I think as the court indicated, I don't know if it was last time or the first time that this case was up, there's some pretty serious health concerns for this defendant if she were to be released, and concerns about what she might do to herself with her substance abuse and whether or not she might harm or kill herself or someone else in the process of that substance abuse. So I just want to make sure that we are addressing that adequately before release. And I would be fine with whatever method that is, whether that's with Mr. Statman or with the individual that Agent Polaris stated. I'm happy to do whatever legwork I need to do to make that go faster. If there's an order for that remote counseling, I have no objection to that order, but I want to make sure that we're doing that before we consider release.
May I respond?
Go ahead.
Thank you. So the issue with the time is that Ms. Henderson, unlike some of the indigent defendants I've represented, actually has some excellent resources that she can use. And they are, I'm sure that Your Honor has heard this, but I would like to emphasize this. Now, Ms. Henderson, it is alleged that she has an issue that is with alcohol. And we know that withdrawal alcohol, although she's been incarcerated for more than 30 days, we know that there were physical effects and psychological effects that go along with getting rid of that addiction. The type of position that Ms. Henderson has allows her to go in without there being any harm to the job that she's held, which supports herself and her daughter. She will be indigent if she doesn't have another form of work or full-time employment, and it is very difficult when you're facing felony charges to be able to find employment, as I'm sure this court is aware. Now, this particular program she goes into, and she also suffers additional consequences once she's assessed. They do a professional assessment. That professional assessment makes recommendations. Ms. Henderson has to follow the recommendations, and if she does not, then her job becomes endangered. Her security is in jeopardy. This is all shared with her work. It's my understanding that all the programs are 6 to 8 weeks long. They're not just a 30-day program, that the assessment may very well put her inpatient. They put people inpatient if they are assessed to be a form of threat to themselves.
This is program through General Motors.
The program through General Motors. There is an issue with Mr. Statman being able to assess her level of addiction, but those resources go away if she loses her job. This program hooks her up with.
But she's on leave, right?
Not for this week. This week is the week where it becomes, her leave becomes, she's expected to be back at work this week. Her leave is ending.
When does your leave end, ma'am?
I was supposed to return back Sunday night, July 6th.
Got it. All right. Go ahead, counsel.
Thank you. The truth is, Your Honor, while it is true that, it's appropriate for this court to weigh public safety concerns, even concern for my client herself, and what could happen, while that's appropriate, there's far greater harm that will happen here. It's not just a potential if she is incarcerated and unable to continue her employment. We are requesting that you put in an order that she immediately be assessed and follow the assessment done by the professionals. We can have Mr. Statman assess her, but he does not have access to those private services, which are actually, if I'm going to be real, they're superior to what community centers can offer Ms. Henderson if she were to lose her job.
I understand and I get all of that. Ms. Polera, have you talked to Ms. Polera, my probation officer, regarding getting her assessed?
I have not, no.
Your Honor, I know, I just spoke with Mr. Cook this morning. He was telling me that they were waiting for someone to get assessed. I had someone else who did an assessment for me at the jail. However, there is a cost to it. So if she doesn't have the funds, I don't know that that could happen.
And that's where it's a catch-22, because if she does lose this employment, she won't have the funds for court costs.
I get all of that, counsel, and that's why I put this actually on a non-sentencing day, because I was hoping to get the assessment, fashion terms and conditions of her release so that we could get her out of here with something in place. But right now, as I sit here, I don't have anything in place. I'm at the exact same point that I was the last time we were here.
I need a written order, if possible, Your Honor, if you would consider it. She did pay Mr. Statman. Mr. Statman's schedule allows for a remote assessment.
Paid him
Yes,
already?
yes, he's been paid. It allows for remote assessment. The jail needs an actual written order from the
Well,
court.
and give me an order. I mean, if I get an order, I'll sign it. I wanted her assessed.
So that's where I'm so sorry that I did email one. Those are the emails that were not received. I would have printed one for you this morning. I can get one faxed if my email is an issue to you. I can fax the same email I attempted to send with the proposed order.
Did Mr. Statman indicate how fast he can get to her if I can get an order
By Friday.
by Friday?
That was my belief. He is making time for her. He waited yesterday. And I was waiting for communication from the court that you didn't receive.
All right. Just
The only thing I would add, Your Honor, is looking at the services that Agent Flora referenced, at least according to their website, they can do within 48 to 72 hours of booking. It's a $200 cost. I understand that the defendant may not have that, but in case something falls through with Agent or with Mr. Statman, I believe that might be another quick turnaround that we could hopefully get through by the end of the week, if that's an option.
okay. I just need to get her assessed. I just want an assessment and a report, given all of the circumstances in this case. How complicated can the order be for Mr. Statman?
It wasn't. It was a one-page order that I proposed.
Then can
Your Honor, would you like me to call Mr. Stanley?
if you would. My problem is that I think from the jail's perspective, I just need an order to get so that the jail will make the proper arrangements so that Mr. Statman can see her.
That's what they told me, yes.
And the place that you have is a 48 to 72 hour turnaround
Correct, Your Honor. And
from the time that they
receive the referral. And I could contact her. I mean, I don't know if it would be up to that. According to the website, they have a fast track one. So I don't know if the assessment price would be less. If it wasn't like emergent. That would be a conversation that I would have to have with her. But I do know that she has gone to the jail or done things remotely via Zoom.
Got it.
And has accomplished an assessment.
All right. So the problem's going to be I'm now here at Wednesday. Her leave ended, you said Sunday.
And I know that this court is aware you could put her on an alcohol tether. She does have court in Shelby Township.
That has counsel. That's always been an option. The problem is the circumstances of this case, and I am doubtful to. I'm not changing my mind on that. I mean, she needs help. We can fashion something so that the public's not at risk, she's not at risk. I mean, the bottom line reality to it is that little girl that was here the other day, her daughter, I can't in good conscience let this defendant out where she may be traveling with that child, if no other reason.
Your Honor, I do not have discovery. I emailed discovery for discovery. I haven't received it yet. I just gave Raymond here a copy of the email I sent over I believe, I will give it to you. Sorry about that. I sent over, but I am unaware of any allegation, and please correct me. I am unaware of any allegation of her being inebriated in the car with her child.
Counsel, that's not my point.
I understand your concern, and I understand that we see things that happen and you need a time machine. Basically, I understand that. I really do, Your Honor. And I really do feel that you're coming from a place of concern. I honestly do, but her daughter is in danger of losing, they're not married. She's been incarcerated. She's the one that has full-time care and custody. Her daughter doesn't need healthcare from the state. They don't need food stamps the way that things stand. So our concern is about what actually happened.
Counsel, she's got a prior, a pending, and another pending. She was a 0.235 in this case. She was making comments that were, and I'm not necessarily qualified to say this entirely, but were of a suicidal nature of what she would do to herself, and that she just didn't care. That's where she was.
And she can be released into a treatment program with doctors and still get a substance abuse assessment instead of the detention where she's not receiving services.
You know what? I'm done arguing about it. I asked that something be done so that I could fashion something or be assured to let her out with as least risk as possible to herself or to the community. I haven't gotten that.
Your Honor,
now I'm here today, counsel, trying to figure out how to make it happen. And so we can keep going around and around. Well, you can keep going around and around because I'm stopping. I'm not going around and around about this. I told you what I wanted. I told you what I needed to try to assess it, to let her out safely. I will do that, but I need it.
Your Honor, may I have a written order denying the motion?
If you get me that order, I'll deny your motion, but get me the order that it gets her treatment, counsel. I don't know why this is so hard. Get the order.
May I explain?
Get the order.
In my email box, your court didn't. And
get the order. I'm done. Take her back. I'll call the case back out, but I'm not going around and around. Get me the order.
I did. I have.
Go ahead.
I'm going to on the record address this so that it's clear. I have proof that I sent the order.
I don't have it, counsel. So that means we can't do anything.
That is correct.
I'm not saying whether I believe you or not. I can't do anything. I can't keep going around and around about this. I need an order so we can get her assessed. Everybody here wants her assessed as expeditiously as we possibly can. But I'm not going around and around about it. Let's just get it done. Ms. Polera, what were you going to say?
Yes, Your Honor. I just wanted to update the court. I did just speak with Mr. Statman. He indicated that if he has the order, he can do it as early as tomorrow at 10 a.m. He tried to do it.
Get me an order. Somebody, I don't care if it's handwritten. Get me an order, counsel.
Yes, Your Honor. I attempted to, and I will make.
Oh my! I hear you. Get me an order. Get a piece of paper. Write an order so I can get her assessed.
Oh, yes.
Right now. I'm done. Step away from my podium. Court is standing in recess. Court recalls case, People versus Nicole Henderson.
Morning again, Your Honor. Raymond Cook for the people.
Good morning, Nicole Shardy. I'm still present, and Ms. Henderson. is walking up to the podium now.
Amen.
Nicole Henderson.
All right. We have finally received an order. I've signed that order. Mr. Statman has indicated, Ms. Blair, if I'm correct, can see you tomorrow at 10. The next question I had for Mr. Statman, which I think we got cleared up, is that he can then have a report by 1 o'clock, noon, 1 o'clock tomorrow. Okay. And then what I'll do is I'll adjourn this hearing to July 9th tomorrow at 3 p.m.
I can do that.
All right. And we'll see what we can do.
Thank you.
You're welcome, ma'am.
One last thing.
Yes.
Separate from that, I spoke with defense counsel. I believe we sorted out the discovery issue. We never received the original substitution. I forwarded that now to our team. So that discovery should be coming within the next day, I hope.
So you didn't receive the discovery, but now have it.
So we didn't receive the substitution of attorney or the appearance. We got that now. I think it was the same issue with the emails that were sent to the court and to us regarding the motion where we just never received it. We have that now. It's been sent over and forwarded. So
all right, you're going to buy this. Fine. Thank you.
I have an alternate email address, Your Honor. So I have an alternate email address that is working with your staff. So I'll just make sure everybody has.
Ready on Mr. Wiesner. The court is now on record. Matthew Allen Wiesner. This is file 26-5153 FC. Ryan Ziegler on behalf of the people.
Michael Horowitz on behalf of Mr. Wiesner.
Thank you. And you're Matthew Allen Wiesner.
Yes.
Mr. Wiesner, we're here for sentencing today. Have you had enough time to go through the PSI?
Yes.
Do you need more time to go through it?
No.
Counsel, there were several different objections. I got many of them late, and I'm not saying that as a negative. I got the defense objections, I think, yesterday, and just this morning, the prosecutor's response. I say I don't have an issue with it. I'm not having an issue with it. There was a long holiday weekend, and I expect that the receipt of the PSI, the timing of that also prompted the attorneys need to kind of last minute go through the PSI and then file these objections. Is that fair from a defense standpoint, Mr. Horowitz?
That's correct, John. I had to make inquiries in order to receive the PSI, and I believe I indicated that I received.
Mr. Horowitz, I can barely hear you.
That's correct, Your Honor. I had to make inquiries to obtain the PSI, and I believe I indicated in my challenges that I received it, I think, on the 26th.
Okay. And is that the reason why I just received your response today, because of those same timing issues, Mr. Ziegler?
And Mr. Horowitz had to look into these issues and file his brief. I understood. I told him earlier in the day that he could file it. I wouldn't object to the timeliness. I got it yesterday afternoon, and I filed mine probably after hours yesterday.
All right. And so the court doesn't accept it. It accepts each of those statements. And we'll go through those scoring guidelines objections individually, each one of them from each attorney. The court would note that because this is a victim against a crime victim's offense, a crime against a person, there is the ability to have, obviously, the victim allocute. And because the factual questions involve potentially what a victim would say, the court's going to hear from any victim that's here, if they're here, before I make determinations as to the offense variable scoring. Did the people wish to be heard on that?
Your Honor, I don't believe the victim is present today.
All right. Then that takes care of that. And did you wish to make any statement for purpose of appellate review on that point, Mr. Horowitz?
Not for appellate review. I would just note that witness victim is on DOC monitoring, so the people, everybody knows where she's at. She would be available today if she chose to be here.
Sure. And so in other words, what you're saying is there's not, there shouldn't be any finding by the court that somehow she's unavailable because she wasn't notified. She was notified, she just chose not to be here.
Correct.
Do you have any response to that suggestion?
No, Your Honor.
Let's go through the guidelines challenges first, and then we'll cover if there's any corrections, additions, or deletions. So who prefers to go first? Defense, do you want to state your objections, and then we'll hear the prosecutions?
I'll go first. That's fine. So, thank you. As to the prior record variable objections that I made, the PSI considered two that I don't believe should count. One was the EDAA attempt, which is a low severity felony, should not be granted under PRB5. The other is the taking of a turkey, deer, or bear, or whatever illegally. As to that, I classified that as a regulatory hunting offense and not one of the offenses that are enumerated by the statute, or types of offenses that are enumerated by the statute for scoring a PRV5. And people responded that, things with weapons would count, and responded in a couple of examples of things that would count. One was OWI with an ORD. That's specifically cited by the statute. That's specifically enumerated. So that doesn't help the argument, or the people's argument, rather. And the second was the use of a crossbow or in a vehicle, a loaded crossbow in a vehicle. I'd say that by definition would be a weapons offense, because it is possessing a weapon is the primary elements of that offense. As to Mr. Wiesner's offense, we don't have that record in front of us. There's no indication that a weapon was involved. I think that maybe the assumption is that a weapon would be involved, but it is not one of the elements of the offense. There's just taking one of those animals illegally. And of course, some of the animals within that statute can be taken via track illegally. So there's nothing that says that was a weapon offense. And moving on to,
let's take them one at a time.
Okay.
Just makes it easier in my mind. Mr. Ziegler, your response to the scoring of CRP5 because of the misdemeanor convictions or regarding the misdemeanor convictions?
Your Honor, as to the taken deer, bear, turkey issue, I would say that the term weapons offense is not defined anywhere that I could find in a brief search last night. To my eyes, the logical definition would be any offense where the possession of a weapon is a required element or a required part of the offense. In this case, I don't see any reasonable way that one could take a deer, bear, or turkey without employing some kind of dangerous weapon, be it a gun, a bow, a slingshot. Mr. Horowitz suggested a trap. I would say that a trap that would allow someone to trap a deer, bear, or turkey by definition would also be a dangerous weapon. I simply don't see how you could construe that statute where the element is the taking or hunting or collecting of that animal.
Well, without getting an accident and I drive my truck into a deer, the deer dies. I don't seek permission from the DNR. I load the deer into my car and I get pulled over by police later. An accidental hitting of the deer with my vehicle. I wasn't using my vehicle as a weapon, but I accidentally hit the deer. I load the deer into my vehicle. I'm illegally possessing it. Also, I've illegally taken the deer, and I didn't use a weapon in that scenario, right?
I would say that if you use the vehicle to enable you to take the animal, then the vehicle was used as a weapon, whether intentionally or otherwise.
You're in an accidental scenario?
I would say that the vehicle still constitutes something that it may cause serious injury or death, and therefore constitutes a dangerous weapon under the law.
All right. Any further argument on that particular?
As to item 6, no, Your Honor, but I would note that there was another item that I noted in my brief. I think it was item 26. I'm just going through my brief here. Item 27, Your Honor, was a domestic violence conviction that I don't think either the defense or the PSI author looked at, but it's clearly qualifying. So even if the court doesn't accept my argument as to item 6, there's still 7 qualifying misdemeanor convictions. I would concede the UDA.
Mr. Horowitz, what about the domestic violence conviction?
I don't have any argument about that.
The scoring at PRV5 remains accurate then, and it remains accurate irrespective of what I determined with regard to the hunting or the illegal taking of a deer, bear, or turkey, because it remains the case that the defendant has 7 prior scorable misdemeanors because of the domestic violence offense. The court also agrees, of course, the UDAA attempt is an attempted felony. That's not a misdemeanor. But the taking deer, bear, or turkey is a closer question. I'm not going to score that as a prior scorable misdemeanor. I'm going to correct the PSI to indicate it's an unscorable misdemeanor. I think there are circumstances where you could take a deer or bear or turkey without possessing a weapon. I think probably the vast majority of offenses, and if I had more information, I could certainly score it by preponderance of the evidence. The vast majority, I think, of circumstances where a deer, taking a deer, bear, or turkey in a wildlife conservation violation do involve weapons. But I don't have the specific facts, as Mr. Horowitz pointed out in this case, to make that determination. I could only guess at that. And so I'm not going to score that as a misdemeanor. But because of the existence of a domestic violence conviction, which was not otherwise scored, there are 7 prior scorable misdemeanors, and the PSI remains accurately stored. The scoring remains accurate on that. As to PRV, OV10, excuse me, Mr. Rowlands.
I think OV10 is a much easier case, Your Honor, a much easier question. And OV10 assesses points for exploitation of a vulnerable victim. It requires that the victim be vulnerable within a certain class of characteristics, although it's not limited to those. The court could find something outside of that that makes a victim vulnerable. And it requires exploitation. Both vulnerable and exploit are defined under the statutes. Neither of those apply to this case. This was a fight in a trailer where you have 2 people that were roughly the same size, 170 pounds, 175 pounds. We don't have evidence about their relative strengths or weaknesses.
Well, we have inferences from the evidence. We have the inference that the defendant pled guilty to a felonious assault where he, in his terms of his plea, he threatened somebody with a dangerous accident PSI, which as of yet at least haven't been challenged as inaccurate, that suggests that the defendant punched the victim, strangled the victim, as is going to be argued by the people, and otherwise held her down and tried to rip her pants, or did rip her pants, in holding her down and assaulting her. Those are all facts that are in the PSI, right?
Yeah, I think those would be facts that would be common to most or many felonious assaults and similar crimes that would not involve a particular vulnerability as defined by statute or exploitation as defined by statute. Those are certainly unfortunate facts, but those are the criminal offense or the cloud of the criminal offense. The exploitation means taking advantage for the specific purposes, profit, gain,
Or
manipulate to certain ends, right? And then the vulnerability means something that makes the person particularly susceptible. And then the instructions go on to explain that just merely having one of the characteristics isn't enough. You got to explain how there has to be a connection as to how that vulnerability actually was in operation and how it came to be exploited. And this is not what we have here. There isn't a huge size differential, but more importantly, there's no proof of exploitation. There's no real argument even as to how somebody was exploited in the sense of the statute, or how somebody was unduly sensitive or have a vulnerability as defined by statute. That's just not, to my mind, it's not even an argument. So I believe that should be scored at 0 points. The people kind of up the ante and say it is predatory conduct. Therefore, it should actually be scored higher. There is pre-conduct in this case, alleged, but it's not predatory insofar as it still doesn't relate to a vulnerability or an exploitation as defined by statute. This is really, I think, probably the most common example where you see this scored appropriately is in cases where an adult exploits a child and exploits that child's youthfulness and inexperience that makes that child vulnerable in a particular way. And that adult exploits that child usually for personal ends involving sex acts one way or another. That is where we see exploitation of a vulnerable victim, or somebody that has an intellectual disability, or somebody that has a physical handicap, or somebody that has is particularly aged as to make them reliant on a caretaker. This is just not one of those situations. Thank you.
Thank you. Mr. Ziegler, your response to OB10?
Your Honor, I think OB10 is properly scored at 15. I cited People versus Cannon, where they discuss the standards for predatory conduct. I agree with Mr. Horwitz that those types of cases he described are primarily where we see predatory conduct, but the statute and the OV make no stipulation as to those are the only kinds of cases where we can see predatory conduct. Case law says there's 3 questions for the court to consider. Was there pre-offense conduct? Was it directed at one or more specific victims who suffered from a readily apparent susceptibility? And was the purpose of the pre-offense conduct for victimization? I think for the reasons I stated in my brief, all of the answers to those questions are yes. Mr. Wiesner went looking for Miss Berge. They had just ended a domestic relationship. He found where she was staying. He entered her camper before her. He was inside the camper when Miss Berge entered. When Miss Berge entered, the PSI indicates that he was cutting up, I believe, a blanket that belonged to one of her children, and then the assault began. So all of that conduct was pre-offense conduct. It was him going to the place where she was likely to be, waiting for her to arrive there. People versus Houston says lying in wait is quintessential predatory conduct behavior. So I think the standard for 15 points is met. Even if the court does not agree, I think the standard for scoring OV10 at 5 points is also defensible in this case. The defendant is heavier, he is taller, he is more muscular than Ms. Berge. And for the reasons the court said, the PSI indicates several facts that give rise to a reasonable belief that he exploited those things during the assault. He pile drived her into the floor. He pulled her back into the camper by her pants, ripping the belt loops on her jeans. She was unable to escape of her own volition and her own strength. So I think even if the court rejects predatory conduct, scoring in the PSI is still proper.
Thank you. The attorneys are aware that the scoring is by a preponderance of the evidence, and the court is entitled to consider all record evidence in making its scoring determinations. I have to score the highest amount that I can under the guidelines ranges as long as it's supported by a preponderance. And so the court can look at the PSI, the briefing that's been done by the attorneys in terms of the factual information that's supported from a police report, preliminary examination transcript, and any other record evidence. In this case, the court finds that 15 points is appropriate to score under OV10. The court would note that under People versus Cannon, the prosecutors correctly articulated the standard, and that is I have to find that there was pre-offense conduct. Pre-offense conduct in this case has been developed already as a factual matter, but the court finds by a preponderance of the evidence it's also convincing that there was pre-offense conduct and that the defendant was the person who arrived at the victim's place of abode. It was a camper, and that the victim's description, at least from the PSI, which is in the PSI, is that she was shocked to learn that he was there because she had been in hiding and had been moving her camper on at least the one occasion over a period of 5 weeks. He indicated, at least during the preliminary examination, as referenced by the prosecutor, that when she arrived, the defendant was cutting up a blanket. The defendant took issue with that at a prior plea proceeding and described that he could not have cut up the blanket, but the allegations remain. And the allegations speak to the shock that the victim felt in having Mr. Wiesner in the motorhome or the camper at the time. That was pre-offense conduct. The conduct that was ultimately engaged in, which by Mr. Wiesner's own account was holding a broken broom handle and holding it in a way as a dangerous weapon to make Miss Berge feel that she was going to be assaulted, constitute the elements of felonious assault. Even that offense clearly was directed at a specific victim. And the question then becomes whether or not there's vulnerability, and that's the readily apparent susceptibility of the victim to injury, physical restraint, persuasion, or temptation. And if the contextual background in mind that the parties were in a dating relationship, Ms. Berge claimed that she was fleeing from the defendant. Ms. Berge claimed that she was in hiding and that she had moved her camper to try to evade Mr. Wiesner knowing where she was. In a context of the fact that she was then overpowered by the defendant, based on Ms. Berge's statements as contained in the PSI, there is clear vulnerability. Ms. Berge was susceptible to injury. She was injured according to her statements to police at preliminary examination and as contained in the PSI. She was strangled, she was choked, she was punched, and she had her jeans ripped when she tried to escape and she had been pulled. Clearly that indicates a difference in size or strength, particularly strength, but it also expresses the victim's own vulnerability to that type of an attack. And the third question is whether or not there was victimization as the offender's primary purpose. Under the circumstances that the court has described, the court can't think of a different purpose for engaging in pre-offense conduct. In other words, if the purpose of the defendant were not to assault, harass, intimidate, threat, or wound Ms. Berge, what purpose would he have in going to her residence or her place of abode, the camper, when she had left him 5 weeks ago and had been, in her words, in hiding? So the circumstances by preponderance of the evidence, again, convinced the court that there was pre-offense conduct that was directed primarily at Ms. Berge and that it was for the purpose of attacking her vulnerability. So the court scores OV10 at 15 points. In terms of the next objection, Mr. Horowitz, did you have other objections to the scoring guidelines?
I did not, Your Honor. I have responses to the prosecution.
Sure. I thought you had objected to OV12 as well.
Your Honor, I had asked to score OV12.
Oh, I'm sorry. I'm looking at my briefs backwards. And in terms of the prosecutor's responses then or objections, which objections did you have?
Your Honor, I had objections to OV1 and OV12.
As to OV1?
As to OV1, Your Honor, OV1 is properly scored at 10 where the victim was touched by, quote, any other type of weapon. This is a felonious assault case. The defendant's plea in this case did not encompass him using the weapon or touching Ms. Berge with the weapon, but the court is not bound by simply the factual basis for the plea. The court can look at other facts and circumstances that can be shown by a preponderance. The PSI indicates that the broom was used to strike Ms. Berge. Ms. Berge indicated that it was broken on her back. She also testified to that at the preliminary exam. Given that the plea by necessity defines that broom as the dangerous weapon, and given that there is a preponderance to believe that Ms. Berge was touched by said dangerous weapon, OV1 should be scored at 10 points.
Your response, Mr. Horowitz?
Two things generally. One, the plea was based on threatening with the broom as a dangerous instrument rather than contact. Mr. Ziegler's correct. I believe Your Honor already referenced that was the basis for the plea. The guidelines statutorily say do not score points on felony assault when for the weapon being merely applied. So you would not score points for the weapon being implied. So the question is whether or not there is evidence of a dangerous weapon being used to make contact. I'd say no. And this is a bit technical, but the weapon that was used, and we are almost stretching to call it a weapon, was...
The client admitted under oath that
correct. Correct.
There's a factual basis for it being defined as a weapon. Right?
Correct.
So really,
I'm gonna try to navigate around that.
All right.
Was a broom that is, one of those hollow, cheap brooms that you get from Home Depot or Walmart that Mr. Wisner broke over his knees and threatened the defendant with out of anger, right? To find that it was a dangerous instrument or a weapon, I believe your court would have to look at the method or manner in which it was actually used.
Well, Mr. Horowitz, if you want to make reasonable arguments, I'll let you, but I'm not going to allow you to make arguments that are contrary to law or to your client's under oath statements. It is and was a dangerous weapon because that's what he pled to and that's what the law requires. If you want to argue that it wasn't used to touch another individual, that's a factual argument that's permissible. That's really what the question is did the weapon touch somebody? It's not a question of whether or not it's a dangerous weapon. It was, we've stipulated that it was by offering a plea. Your client told me it was a dangerous weapon. So that fact is settled. The factual question now is there proof in the record that the victim was touched by any type of weapon?
So if I may, I understand your Honor's point, and of course I won't argue your honor. The point that I was trying to make, though, is that whether or not something is a weapon should depend on how it is used. And if I threaten
it is that.
Right.
But you've already conceded by the plea that it is a dangerous weapon. We couldn't be here for a sentencing on a felonious assault if there wasn't already an agreement that it was a felonious assault, which is necessitated by using a dangerous weapon.
Correct. I believe that I could threaten somebody with an instrument in a way that makes it a dangerous instrument, and also concurrently use that instrument in a way that was not using it as a dangerous instrument or weapon, right?
Well, this distinction is meaningless, though, because the question for OV1 is whether or not a victim was touched with a dangerous weapon. The question isn't about Mr. Wiesner's intent. Well, that's already settled. And it isn't about the legal particularities and whether or not you possess a pen and use it as a dangerous weapon. The question is, was the victim touched with a dangerous weapon? If so, 10 points. If not, no points.
Mr. Wiesner denies touching Miss Berge with the broom. He pleaded to threatening with the broom, He broke this cheap instrument over his knee out of anger and threatened with it. Mr. Wiesner denies hitting Ms. Berge with it. And also, I would note that many of the allegations that are made by Ms. Berge at some point start to ring incredible, as the pile driving, the wrestling moves, the extent of what is alleged is probably exaggerated, in that somebody could not perceive those sorts of wounds and not have physical injuries. Somebody could not execute those maneuvers in the space of this trailer that's just a normal trailer, where you don't have the room to pick somebody up over your head. And if, considering these alleged maneuvers in the context of the prosecution's assertion of this, big strength differential between Mr. Wiesner and Ms. Berge, it just doesn't stand to reason that they could have actually occurred. So
the court notes that the standard is preponderance of the evidence, and the defense has a unqualified ability to challenge as inaccurate factual circumstances. And I'm sure we'll hear that in a moment when we get to factual challenges. But the existence of a legitimate or bona fide dispute about the facts does not mean the court can't make a determination as to a preponderance of the evidence. To the extent Mr. Wiesner decided to have a trial in this case, and he explicitly said he did not want to have a trial in this case, the jury would have had to determine those facts, and the jury would have to determine them by proof beyond a reasonable doubt as to whether or not there was a felonious assault or there was the alleged choking offense that was originally charged as a higher offense. That is taken out of the jury's hands, though, and there is no more a standard of proof beyond a reasonable doubt. Instead, the court, as the fact finder, must determine the scoring of the variables. And I have to do that by a preponderance. And when I have two conflicting stories, one, Mr. Wiesner's story, and his story was under his plea that he broke a handle of a broom over his knee and then threatened Miss Berge with it. And I have, on the other hand, a alleged victim, or a confirmed victim now, story that she was hit with that same weapon. The question is whether or not the evidence or the court's conclusions preponderate in one way or the other. In this case, the background of this case also helps the court make that determination. And the background of this case is, in general, the statements that Mr. Wiesner has made, the communications I've had to have with him throughout the case, the very difficult nature of many different prior hearings, and the fact that Mr. Horowitz, I think you're at least the second or perhaps third attorney, there's been problematic communications between the defendant and his attorneys in the past. All of those things enter the court's mind in terms of credibility assessments. And when I have to make a credibility assessment between a victim who says that she was attacked, she was hit with a weapon, which the weapon was a broom, when the PSI indicates and the police reports have indicated that there was a broken broom that was discovered in the camper, and when the defendant, in his own plea, indicated that he did use a broom handle as a weapon, the court finds that the evidence preponderates towards believing the victim over believing the defendant's denials. So if it's a close case, it may be the evidence still preponderates in favor of the fact that Ms. Berge's statements are entitled to belief. And even if they weren't believed by a jury by proof beyond a reasonable doubt, for purposes of a sentencing hearing, I'm convinced by a preponderance of the evidence that the victim was touched by a weapon, and that was the broken broom handle. That's, of course, the scoring is only 1 at 10 points. In terms of the next objection that the prosecution had.
Your Honor, very similarly, OV12. OV12 was scored at 0. OV12 is properly scored at 5, where there was one contemporaneous felonious act against a person that doesn't result in a conviction. In this case, there were 2 felony charges, the felonious assault, which the defendant pled guilty to, and the strangulation was dismissed for very similar reasons, given that Ms. Berge made those statements at the time, given that she testified to them at the preliminary exam, given that the defendant pled guilty for dismissal of that higher offense. I do believe there's a preponderance of evidence, at least, to believe that Ms. Berge was strangled and that therefore the defendant did commit a contemporaneous felonious act. Therefore, OV12 should be scored at 5.
Mr. Horowitz, your response.
Your Honor, again, I don't believe that the record supports a credible determination that everything Ms. Berge said happened. I would also argue that I believe that there's probably that these are all part of the same transaction. They're all part of the same course of conduct, and probably there's some merger issues or double jeopardy issues as to counting the various aspects of this one singular course of conduct as separate offenses. Thank you.
Thank you. So the court notes that for all of the same reasons that I indicated in the scoring of OV1, the court considers the totality of the information that's been provided, including the preliminary examination transcript, including the PSI itself, and including the briefs of each of the attorneys. That's the totality of information the court determines in deciding whether or not there was a contemporaneous felonious criminal act. As the attorneys well know, that by statute means that there was another felonious act that occurred, that was charged, and that will not result in a separate conviction. In this case, the argument for the defense is that that is subsumed in the same events, and the court ultimately disagrees. If the same elements were in place or the same act was resulted in multiple charges, I would tend to agree. But this is many separate different acts or allegations that are involved. And again, by a preponderance of the evidence standard, for the same reasons I found credible the statements of Ms. Berge as contained in the PSI, I finding them credible for OV12. Ms. Berge didn't just claim that Mr. Wiesner had threatened her with a broken broom handle. She testified at the preliminary examination, apparently, and the PSI suggests that what happened was that he broke it over his knee and then hit her with it. She also testified that at previous times there was a struggle from the PSI language itself. The indication from the victim is that she didn't know how Matt found her, and she'd been hiding for 5 weeks. Nobody knew he was there, how she was there, and she moved the camper to this location the day before this happened. As soon as Matthew saw her, he pile drive rose into the floor and placed her in a chokehold and started punching her in the face. That's the first description. Then later on, she says, when the attack was going on, Matthew heard the homeowner Caleb Gibby. That's when he paused the attack, then broke a broom over Rose's back. That's the contact with the weapon, and fled out of the camper a little after the Caleb, who instructed Rose to go inside the house and call 911. In other words, temporally, it appears that there's a different, although it's an ongoing event that's going on. First, there was Mr. Wiesner's alleged choking, putting his hands over her and putting her in a chokehold, and started punching her in the face. That would be a separate felonious criminal act by preponderance of the evidence of assault by strangulation. Then he broke the handle once he heard Caleb Kitty outside, and then that's when he committed the felonious assault that she ultimately pled guilty to, although he again did not acknowledge touching with the weapon. So the court finds that there is indeed, by a preponderance of the evidence, additional felonious criminal activity that's charged. It did not result and will not result in the conviction. Therefore, 5 points is appropriately scored. Did you have additional objections to the guidelines ranges, Mr. Ziegler?
I do not, Your Honor.
Do you, Mr. Horowitz?
No, Your Honor.
The court's going to count up then the scoring that I have: 10 for OV1, 5 for OV3, 15 for OV10, 12 or 5 for OV12. That would be 35 points total. 35 total points with a class F crime, PRD level E. 35 would be level 3, making the guidelines range 12 to 24. The attorneys want to be heard on those mathematical calculations.
I agree with that, Your Honor.
No, Your Honor. Based on the court's findings, I believe that calculation is accurate.
All right. In terms of the background of the PSI, Mr. Horowitz, do you have challenges to the background of the PSI, the factual circumstances?
No, Your Honor.
Mr. Ziegler, do you?
No, Your Honor, I just have a typographical correction that the court has already hit on. On page 2 under the description of offense, the witness was named as Caleb Kitty. It should be Caleb Kibby, BBY.
Any objection to that change?
No, Your Honor.
The court will make that change. Elocution on behalf of the people.
Your Honor, Mr. Wiesner is before the court for sentencing on 1 count of felonious assault. This will be his 17th conviction overall. Among those, he has numerous convictions for theft offenses and several assaultive crimes, including an R&O, a domestic, and an assault and battery. His record does not recommend him well to community supervision. In the instant case, he was in a relationship with Ms. Berge. Following that relationship, Ms. Berge apparently went into hiding, staying in a camper at a friend's house. She indicates in the PSI, or in the information in the PSI, it indicates that she had moved at least once to try and avoid Mr. Wiesner. Apparently, her fear of Mr. Wiesner was well justified in this case, because somehow he managed to locate her entered her camper without permission and assaulted her. The assault only ended because Mr. Kibbe noticed a struggle in the camper, and upon seeing Mr. Kibbe, Mr. Wiesner fled the scene. According to the victim's version of events, she was strangled, and the defendant broke a plastic broom across her back. While Ms. Berge historically has not been the most credible or reliable witness in other matters, she did appear at the preliminary exam, and she did testify under oath to those facts in this case. She also had redness and abrasion on her face consistent with the struggle. There was a broken broom consistent with the struggle. That's all in the PSI. Caleb Kibbe also appeared and testified at the preliminary exam, and identified Mr. Wiesner as fleeing from Ms. Berge's camper. All of that is to say that the offense itself, as described by the victim, was fairly serious in nature, Your Honor. While the weapon itself, I would admit, and I think this is what Mr. Horowitz was trying to get at, was probably on the lower end of what might constitute a dangerous weapon. The fear the victim felt, or likely felt, having her camper entered by someone she was trying to get away from and avoid, and then being attacked by that individual, that fear was certainly significant to her, regardless of how dangerous the weapon may have actually been. This was also not a crime of opportunity. It's clear from the facts that the defendant must have sought her out with this purpose in mind, to find her at Mr. Kibbe's property and to find her camper there and to enter her camper there. This was not a chance encounter. With the guidelines of 12 to 24, Your Honor, I think a prison sentence is called for. This would not be the defendant's first prison sanction, and he's had numerous jail sanctions over the years. His history and the severity of the offense do not call for a low-end guideline sentence. If anything, they call for a sentence at the higher end of the guidelines range. Tracking down a specific victim, targeting them for abuse and victimization, with a concerning criminal record to boot, all suggest to me that a higher end sentence is warranted. I also have very little belief that Mr. Wiesner is likely to reform his behavior, given his history. I strongly suspect that when he is released, he will return to the same types of behavior, just as he did from his prior release from prison some years ago, Your Honor. So for all of those reasons, I would ask the court to impose a sentence of 20 months MDOC.
Thank you. Mr. Horowitz, on behalf of Mr. Wiesner.
Your Honor, I think the probably most helpful thing to say on behalf of Mr. Wiesner is to actually point to Your Honor's earlier statements today about your prior interactions with Mr. Wiesner and Mr. Wiesner's prior interactions with counsel. That is to say, it was heated, contested, and Mr. Wiesner was quite simply a different person. When I began representing Mr. Wiesner, I didn't have any of those issues. And since I've been in court with Mr. Wiesner, he hasn't had any of those issues. When I first met with Mr. Wiesner, I was struck by the fact that I found him exceptionally sharp and exceptionally well-spoken. It's not because he got a new lawyer that makes the difference. It wasn't that he had Mr. Trevis before that made the difference. His medication has been switched. He has been medicated differently in the jail. That medication has greatly enabled him to conform his actions to what we all find acceptable. He's even keeled. He's able to exercise patience. He's able to listen to allegations against him that probably don't feel good to hear and isn't reacting to them. I mean, he's reacting to them, certainly, but not reacting inappropriately to them. Frankly, he's doing great, I think. And I think looking at the the contrast between what the court's seen before and what the court's seen over the last couple of hearings shows that, one, he's capable of reform and rehabilitation, but two, that a lot of what he's been going through is a result of intellectual and mental health difficulties, probably long-standing, and that this medication is really necessary. And without it, he just doesn't have the same, I guess, intellectual and mental health opportunities that the rest of us have. So looking at him from before to today, I think is a huge contrast. And I think that recommends that the court should not impose the highest sentence it can. I think the court should consider, especially given the severity or lack thereof of the dangerous instrument involved in the sentencing offense, that the court should consider imposing a sentence of 12 months, a local jail sentence. That said, we acknowledge Mr. Wiesner's record. We acknowledge that it's long. I believe in between Mr. Wiesner's last prison sentence, and he had a strong period immediately following that on supervision of succeeding on parole, probation, and was out, I believe, 7 years or something like that. So I think when the stars align and when he gets his medication adjusted correctly, he's totally capable of doing what we need him to do. So with that, I'd recommend the court impose a sentence at the low end of the guidelines. Thank you.
Thank you, Mr. Horowitz. Mr. Wiesner, was there anything you wanted to tell me before I impose sentence today?
You made a mistake and got to deal with it. Oh, don't I know what to say? Other than sorry.
Thank you, Mr. Wiesner. I appreciate that. I appreciate that you understand you made a mistake, and I do take stock of the fact that this situation today, in terms of your reaction to it, is starkly different than you have been in the past. And I credit you for that. That's a circumstance that I frankly didn't expect, because you and I know we've had some history of difficult interactions. And so I credit what your attorney has claimed is that that is a result of a couple of different things. Probably A, is taking responsibility, you taking responsibility for the fact that you're here. You took that same responsibility during the plea by acknowledging that you were guilty and wanting to take advantage of that plea agreement and acknowledge it. And you clearly and unambiguously told me you were guilty. I didn't necessarily expect that either. And I say that only because that taking of responsibility is an important factor to the court in assessing what's a fair sentence. In those situations where I find that a defendant isn't taking responsibility, it makes me less likely to think that they're going to be capable of rehabilitation. And so the fact that you are taking responsibility for your wrong actions is somewhat significant to me, because I didn't expect that. I think that it's fair for you as well to contest the factual information, meaning I don't penalize you for contesting the factual information that I ultimately determined, or that you disagree whether or not there was a touching by a victim of a weapon, or that you disagree that there was a strangulation. Those are all fair things for you to disagree with. And you didn't even touch on them. Your attorney did as an advocate for you. I don't hold that against you in any way. Those are important distinctions, and they have an important impact on your sentencing guidelines as well. Your guidelines were 10 to 23. Now they're 12 to 24. So those things matter to me as well. And I don't count those against you. I did find those facts in against your favor, but I don't hold you any ill will because you contested the factual accuracy of those claims. When I look at the background, the most striking thing to me is that you have now your 9th felony conviction as of this conviction and 8 prior misdemeanors. 4 of them prior were assaultive. Those assaultive convictions really only started to happen when I looked through the PSI no later in life. You had a lot of theft-related offenses. I'm not minimizing those, but to the court, the assaultive convictions are the most concerning because they reflect on the seriousness and the danger to the public and that these type of circumstances indicate. And your attorney's right, even though I think it's very serious when you assault somebody with a weapon, touch them with a weapon, by preponderance of the evidence, assault them by strangulation. The severity of the weapon involved, it also is a consideration. It's not a way to minimize the offense, but it's a way to take into account the fact that there are many different types of weapons that can be involved in assault. An assault with a gun is more serious and therefore deserves a stronger punishment than an assault with a different weapon. Again, that's not to say that this assault was not severe. It appears to me to be very severe. So severe reaction is in order, but I think that severe reaction can also be tempered fairly with your responsibility taking, the fact that you're sorry for making these bad decisions again, and altogether that points me in the direction that I think I need to be in. which is a sentence within the guidelines range. It happens to be a sentence within the guidelines range of the original guidelines. It wasn't much of a change again. I think an 18-month sentence for this type of an offense, for this type of individual is fair in proportion to the circumstances, and that's what the court will issue is an 18-month minimum prison term up to a maximum of 4 years. You do have credit for 191 days that you previously served. The court will order the crime victim assessment of $130, court costs of $325, attorney's fees of $350, and a state cost of $68. Those fines, costs, and assessments are due today. By state law, if you don't pay them within 56 days of today's date, a 20% late fee gets added on. Mr. Weasley, you do have the ability to ask for leave to appeal. You can go through those appeal rights with your attorney. The top copy you sign just indicate that you got the rights. The bottom 2 copies are yours. If you wish to ask for leave to appeal, fill those out in their entirety and turn them back into the court. Mr. Howard, other than going over the appeal rights with your attorney, with your client, do you have anything further for today?
No, Your Honor, thank you.
Mr. Ziegler, anything else today?
No, Your Honor. Your Honor, we'd acknowledge receipt of the notice of right to appellate review. Mr. Wiesner signed that, and we're returning that. Okay.
Thank you.
Thank you, Judge. Appreciate the case. No, that went over a little bit.
Our next calls a matter of People versus Kendra Murray Hiddle. This is file number 26-5192FC and 26-5162FC and 5163FC.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger, pen with on behalf of Ms. Hiddle.
Thank you. Are you Kendra Murray Hiddle?
Yes, sir.
Ms. Hiddle, we're here for a sentencing today. Did you have enough time to go through the PSI?
Yes.
Do you need more time?
No.
Mr. Seeger, do you have corrections, additions, or deletions?
No, Your Honor.
Do you believe the guidelines were accurately scored in each offense?
I do, Your Honor.
Mr. Ziegler, do you have any corrections, additions, or deletions?
No, Your Honor.
Believe the guidelines are accurate?
I do.
As I read through the PSI, gentlemen, I want to make sure the attorneys have a chance to point this out before I make a determination or to make argument on it. There seemed to be a suggestion that you had advised, prosecutor's office advised that there may be consecutive sentencing, which is applicable. The way I read the PSI, it seemed to be that the one offense she was charged with, it may have been a situation, I want to ask for clarification, that you waited for a lab result before you charged, and then she was arrested on the outstanding warrant at the time she was arrested for the second offense, the resisted obstructive offense. So is that factually how you think it happened?
Yes, Your Honor. I do agree that consecutive sentencing does not apply. I did not speak directly with the author of this report. I may have said in passing to someone at MDOC that I had thought consecutive sentencing might apply. But in reviewing the facts of the case, she was arraigned on the same day on both of these matters.
All right, and that's how I read it, but I wanted to make sure I wasn't missing something. Mr. Seeger, do you agree under these circumstances, consecutive sentencing is not applicable?
Yes, we were going to adjust it during the course of sentencing if it became relevant, but yes.
And I agree, again, based upon the facts that are outlined in the PSI. Anything else on behalf of the people regarding the PSI background?
By way of addition, deletion, or correction, no.
Any corrections, additions, or deletions other than that, Mr. Seeger?
No, sir.
All right, allocution on behalf of the people.
Your Honor, I appreciate the recommendation of probation and parole in this case, but I do not agree. Ms. Hiddle is well deserving of prison in these matters. She's before the court for 2 felony convictions for R&O and possession of methamphetamine. There's also a misdemeanor case where she fraudulently scanned bottle return slips multiple times to the tune of $357.70 that's been rolled into this global resolution of her files without additional conviction. That restitution is part and parcel of the PSI.
That's the $357.70.
Correct, yes. These are her 24th and 25th convictions by my count. She's only 40 years of age. She has had, by my count, 12 prior jail sentences in her life. I cannot agree with the implication inherent in the recommendation that a 13th jail sentence is likely to lead to rehabilitation or to send a strong deterrent message to the offender or to the community. On the contrary, it seems to send the message that you can continue to reoffend repeatedly and local time is the only consequence that you're likely to get. Looking at the defendant's history, past the history to the offenses themselves in this case, they also suggest to me a prison sanction is warranted. In the first file, the possession of meth, she was pushing an empty stroller around midnight. Police were called due to the suspicious nature of that behavior. She was found to be in possession of multiple pipes, syringes, and baggies. When Sergeant Beaver saw a pipe in her hand and asked her about it, instead of handing it to the officer, she threw it into a field. where it was never recovered. The other paraphernalia that was subsequently found did test positive for methamphetamine. In the second file, Kendra and Ryan Hittle were spotted by law enforcement, where they knew that Miss Hittle at least had a warrant for the prior incident already outstanding. While law enforcement was focused on Ryan Hittle, Kendra ran off across the street into a separate private business and locked herself in a bathroom in that business. She did not come out despite law enforcement's repeated commands to that effect. Law enforcement had to locate an employee, get a key to the bathroom, and when they entered, they found Kendra kneeling by the toilet, apparently attempting to flush suspected contraband down the toilet. Both of these offenses involve blatant obstruction of justice. Both involve suspected possession of controlled substances. Both involve tampering or destroying evidence. These offenses are not atypical for Miss Hittle, with her record containing a prior attempted R&O from 2010, for which she got a 3-month jail sentence. She also has prior drug offenses, ignoring the alcohol-related ones. She has a possession of analogs from 2010, 6 months jail on that. A possession of marijuana in 2014, 90 days jail on that. With the guidelines of 5 to 23, this court should not allow Ms. Hittle to continue to do local time sanctions when it is abundantly clear she will not and cannot learn anything from those punishments. The definition of insanity is doing the same thing over and over and expecting different results. 12 jail sanctions, including 3 for drugs and obstruction, have not deterred her one iota. Before the clock strikes 13 on these jail sanctions, it's time to try some harsher medicine. At best, it may deter her from committing further crimes, although I doubt it. But at worst, at least she will be physically unable to continue her pattern of drug theft and obstruction crimes for an appreciable period, and it may help deter other offenders who would otherwise get the message that repeatedly obstructing the police is worth the risk if these are the likely consequences. A sentence of 20 months is more than justified on the primary offense, Your Honor, and that's what I would ask the court to impose, or at least a prison sanction of some stripe. Thank you.
Thank you. On behalf of Ms. Hill.
By way of allocation, the only thing that I can say is I don't disagree, and I've known Ms. Hittle and I've represented Ms. Hittle quite a few times over the course of her lifetime. And
Mr. Seeger, you need to speak up.
Sure. Yeah, I'm sorry. Your Honor, I've represented Ms. Hittle quite a few times during the course of my legal career. I've represented family members. I recognize that she struggles with substance abuse. It has caused a lot of problems for her. Historically, it has caused a lot of problems in her lifetime. She has constantly struggled with substance abuse problems, either by her own choice or by virtue of being involved with other people who are using similar like substances. But through it all, Your Honor, she generally has tried to change her behavior. Clearly, she continues to have a drug problem. I don't see any benefit to sending people to prison unless we're specifically saying that they were dealing drugs in some meaningful capacity, which is not the allegation here, Your Honor. She's alleged to have been in possession. I shouldn't say alleged because she pled to it. She pled guilty to possessing drugs, Your Honor. She didn't plead guilty to selling drugs of any commodity. And I agree with Mr. Ziegler that there are usually elevated penalties for people who continue to come back to court. But in this particular instance, Your Honor, I can't say that it benefits anyone because whether you gave her jail time, you gave her probation, or you sent her to prison, Mr. Ziegler hit the nail on the head. He can't even specifically tell the court that it is somehow going to change her thought process in terms of not using drugs or her ability not to use drugs, because it's really only self-destructive behavior for herself. Your Honor, she's not a danger to the public per se. And I understand that there's this allegation that she was tampering with evidence. And that's great that Mr. Ziegler points that out, but there was no pipe that was recovered. So we don't know what evidence that was. So I don't know how far she threw it.
So she should classically tamper with evidence.
Okay, well, I'm just saying, I'm just playing off of what you said, Your Honor. And when they find her in the bathroom, they didn't find any similar like items in the bathroom. So we're making the allegations, and the court may even find by preponderance of the evidence that those items are true. I'm just merely saying that I don't see any benefit to sending her to prison because no lesson is learned there, Your Honor. Really what we should be leaned at is trying to assist her in getting some kind of rehabilitation. But because clearly going to jail, as Mr. Ziegler pointed out, has not necessarily changed her choices or addiction. Really what she needs to focus on is getting into treatment of some sort, which she's indicated she wishes to get involved with treatment, which maybe she will, maybe she won't, Your Honor, but going to prison is not going to improve her life or her children's life in any particular way. She recognizes that she's got to make changes. She has good family support, at least from her mother. She's been a long-standing member of the community. Whether she does jail time, whether she does probation, whether she goes to prison, she's likely to come back to the community. And the only way that we're going to stop the cycle is by allowing her to get into treatment, some kind of meaningful treatment, as opposed to just sending her to prison. Because I don't really see what that cures in any way, Your Honor. So she goes to prison for a period of time and then she comes back. Well, okay, she's either going to use drugs or she's not. She's not going to have the tools. I've never seen anybody go to jail and or prison and come out a better person, you know, because when they went in there, they didn't have anything. And now when they come out, they have even less. So I really struggle with the idea of sending her to prison. I also somewhat struggle with the idea of probation because I don't necessarily disagree that probation may not be the best feature for her. And maybe if the court was going to give her a sentence, it would be a straight jail sentence with the ability to get into treatment at some point in time, whenever the court deems that to be, fair and reasonable. The guidelines are 10 to 23, maybe somewhere towards the end, wherein she can at least she's served an appreciable period of time already up until today's date. Maybe she can get into treatment immediately. I would much rather somebody use their time wisely as opposed to just idly sit in jail. The idea that, the general public receives a message from somebody serving jail time is absurd. And it's absurd because I don't know how many drug cases were on your docket today, Your Honor, but none of those people seem to have gotten the message, right? No matter what it was that the court did. Because when people have an addiction, they're not thinking about whether or not they're going to go to jail or whether or not they're going to go to prison. They're letting their addiction make choices that they otherwise probably wouldn't make if they maybe had the tools. And maybe they would still make the same decisions, Your Honor. But hopefully, with some tools, with some treatment, she's able to curb what will probably be a lifetime addiction for her, but at least she'll have some tools to address those things going forward. And speaking with Ms. Hiddle, she's just hopeful that the court will not impose a prison sentence. She's hopeful that the court will allow her to get into treatment. She did wish to speak on her own behalf in advance of sentence.
Ms. Hiddle, was there anything you wanted to tell me before I impose sentence today?
Yes, I'm sorry being brought before you on these charges that have been committed. Being in jail has opened my eyes and I realize this is not the way I want to live. I've hit rock bottom since being in jail. See everyone that I've hurt and let down. My kids. Since my dad died, he was my best friend. My life went on a downward spiral. Couldn't live with him being gone. I have let my kids down and they just want their mom back. I have a good support system. I have 3 amazing kids I'm ready to get back to and be their mom. I accept full responsibility for my actions and just ask that this court give me the least sentence possible and the chance at house arrest or tether or rehab. I guarantee you will not be disappointed if you give me the chance. I show everyone I can do this. Thank you for your time.
Thank you, Ms. Hiddle. I've gone through the entirety of the PSI. I'm aware of the factual background here. I'm aware of the fact that there was a warrant that was issued. You were not on bond. So I'm going to make that correction to the face sheet of the PSI. Counsel, is there any other suggestion that she was on bond to a different, in a different place? No, Your Honor. I didn't think there was. Mr. Seeger, any objection to that change to the PSI?
I do not.
And so it's clear to me that these circumstances happened very close together. They were individual circumstances. I've had a chance to go through all of that and to consider it. PSI has not been challenged as inaccurate. It suggests that the last time you tried to get any sort of treatment was some treatment in 2009. You've done nothing since that. So to the extent there is a suggestion that you need treatment, that appears to be clear. You have an addiction. But needing treatment and taking active steps to seek it out are 2 different things. And the way that the court reacts to the lack of proof of the latter steps taken to try to get into it is to not really consider it. If there was significant information presented to me to show that you had a plan in place for treatment, you had a bed available, for example, I would look at that as a rehabilitative factor in your support, in your favor. I don't have that information in this case. What I have is a relatively young individual, 40 years old only, being sentenced now on your 5th and 6th felony. You have 19 prior misdemeanors. You've served a litany of prior jail terms. The prosecutor counted 12. I didn't count them. And the argument that's made for you is that I shouldn't send you to jail or prison because it doesn't benefit you. Courts don't impose criminal sentences on felonious actions to benefit people. Courts are reactionary to criminal conduct. And the reaction has to be based upon a combination of what you did and the background that you bring to bear. What you did in this case, while on its face, it originally possessing some small amounts of methamphetamine is not the crime of the century, the things that involved and that circulated around that possession are fairly concerning. You possessed it, you were acting irrationally, at least according to the officers in the PSI, and you threw an item of potential, perceived, by a preponderance of the evidence, paraphernalia, and the police couldn't even find it. It was midnight, and I don't know how hard they searched for it. But you clearly tried to interfere with the ability of them to find that illegal item, the item that I presume, and by preponderance of the evidence was illegal. Yet you had many other items of illegal conduct on you. You were arrested later, attempted to be arrested, and you ran from police. You ran and hid and barricaded yourself in a bathroom and had to be physically forced out, even fighting against the police, then acted as if you were throwing up, and in what the police viewed as you're trying to, again, evade capture and interfere with the administration of justice and flush other items. Whether or not you're successful is really irrelevant to me. It's the conduct that surrounds. It's a police officer assault, resist, or obstruct, but it's the conduct that surrounds it and how it happened. And after a long history of serving prior jail terms and hitting rock bottom, I'm guessing, before. So I don't look at a jail sentence or a prison sentence to benefit you. I look at punishing wrongful conduct, taking into account whether or not there's rehabilitative potential, and I don't really see much here, and you haven't offered any proof of it. And I try to send a message to the public and to the defendants, a message that if you continue doing the same thing over and over, the penalties are going to continue to rise. Because when we have a system that's based on rules and laws, and then if you continue to violate them, there needs to be some sort of a reaction. And it's not my personal view that a reaction should be, well, prison's not going to work, so let's not do it. Jail's not going to work, so let's not do it. I think that turns the system on its head. And what I view as more fair and more reactionary to your criminal conduct is to increase penalties if you keep coming back into the court and committing criminal offenses. Particularly when you have 19 prior misdemeanor convictions and 4 prior felony convictions before these 2 felonious convictions. So the court finds that a prison sentence is warranted in this case. It's my hope that it sends a message to members of the public and to you.
Can I say something? I have called the reading.
So I don't need to hear anything further from you, because if I allowed back and forth commentary, I would never finish court hearing. That's why there's a structure and order to it. So the prosecutor talks, then the defense attorney, then you and me. Even if I have not heard what you would say, for example, you're telling me that you may have things set up in terms of rehabilitation, the impact of your decisions, continuous decisions, still needs a response. And even if you had a plan in place for rehabilitative potential, that would not outweigh the dangerousness of the way you've carried yourself. Dangerous to yourself, the involvement of multiple law enforcement officers who had to fight with you to get you out of a bathroom, all of those things, and including, of course, the prior felony convictions and 19 prior misdemeanor convictions. The guidelines within the guideline sentence appears reasonable to me. Towards the top end appears reasonable and commensurate with the circumstances of the defendant and the offenses. And so the court finds that for the methamphetamine case, 18 months in the prison system, Michigan Department of Corrections is warranted and is justified. That would be up to a maximum of 10 years. You do have credit in the methamphetamine related case of 152 days. For the police officer, resist, obstruct, or oppose, 1 year in the county jail. That is with credit for 150 days. Those will run concurrent to each other, in other words, at the same time. The court will impose fines and costs as were outlined. The court will impose a $130 crime victim assessment, I'm striking the supervision fee, $325 in court costs, $350 in court appointed attorney reimbursement, DNA testing fee of $60 and a $68 state fee. In the resist and obstruct case, $68 state cost and $130 crime victim assessment. By state law, those fines and costs are due today. If they're not paid within 56 days of today's date, a 20% late fee gets added on. You do have the ability to ask the Court of Appeals for leave to appeal. You can appeal those rights with your attorney. The bottom half is your ask for leave to appeal.
Your Honor, the only question, I think it was alluded to in the report, that to the extent that the court elected to give her a prison sentence, it was wondering whether or not you would to make her eligible for boot camp if she's selected as eligible.
I don't make that determination at the time of sentencing. I wait to hear from the department if there's eligibility for SII, and then I reflect back on the PSI that I copy of, and I make the determination post sentence. The restitution, thank you, is outlined in the PSI. I'm going to order it. It was a total amount of $357.70. That full amount is dispatched and going to be paid to the Kalkaska County Clerk's Office for the use and benefit of village markets. Thank you for reminding me of that.
Thank you, Your Honor.
Yeah. I don't need to hear anything from you. You know, if I just let this be back and forth, and we'd never get this show done. Ever. Look at all you guys talking over there. Talking all the way through the show. Chat. Love you guys. I want to say thank you very much to Stephen, the objectioner. Darth Stephen, that is. He wanted to send out a let's get this show rolling super chat, and he did it. And then Vegas Starlight followed it up with another fun little super chat with a little bear thing dancing with it looks like heart coming out of its butt. Yeah, that's a thing. And then Spec sends a super chat saying, thank you, Wolfie Pack fam, for being awesome and kicking butt. My cockles are extra warm tonight. And big smiles to that. Yeah, ladies and gentlemen, it's been a fun night. It's been an amazing night. I want to thank you very much for hanging out with me. These have been the cases I have found, and tomorrow I will find more. Same Wolf time, same Wolf channel. Come on by and hang out with me. Thank you to everybody who sent jewels and super chats tonight. I'm turning in early. I've got company, and I'm gonna say thank you to everybody and just let things roll on out. Oh, speaking of rolling, let's let those credits roll, shall we? Thank you, Mama. Thank you, Shiloh. Thank you, Specs. Thank you, Vega. Thank you, Darth Steven. Thank you, Rhonda. Did I say Rhonda already? Did I say Northwest and Barry and Marty? I know you're out there, Marty. Marty, you better do the thing. You hear me? Hear me out there, Marty? You do the thing. There's Idly Wild. Dale's here. Kristen, Marty. Look, hey, Marty, you're here. Mr. Beeps, what's up? Magi, I know Hutch is out there somewhere. He may not be showing up here. Mark Baggett, great to see you. Katie, Zed, and Colin, thank you so much for the raids tonight. And for everybody who came over with the raids, thank you for hanging out. It's been amazing. Chat's been awesome. I've been watching chat as much as I can when I haven't been distracted talking about interesting things with my cousin. But that's how it goes. Some nights you eat the bar, and some nights the bar eats you. You know where that comes from. You know a thing or two. Ladies and gentlemen, I'm your Lone Wolf Oozle. And for now, just for now, I am out. Whoa! I see a Nate Soldier of Providence. What's up, dude? Thank you for being here. I didn't say thank you. If I had seen your name sooner, I would have shouted you out. What's up, dude? Great to see you. Barry? See. Hey, Jason, Rhonda says hey. He says hey. Says hey back. So, yeah. Night. You guys stay cool. You know, party on, dude. Stay excellent to each other. Fight out of crime. Bye. And remember, only you can take a bite out of crime. Bye. Stop laughing. Stop. Stop. Okay. Keep laughing. Why are you still here? I have nothing else. Go away. Bye. Bye. Wait. Am I doing it right? No. Is that how it goes, Mark? Bye.